This is one of those topics where the standard advice and the actual rule are pulling in opposite directions. The standard advice tells you that the moment you retire, you celebrate. You tell your family. You change your LinkedIn. You let your alumni newsletter run the photo. You print a card for the office party. You reply to the goodbye email with the date and the title and the smile. The current state of identity theft data, elder fraud reporting, and aggregator behavior has been telling a different story for at least the last 8 years, and almost none of it has reached the kitchen table where the actual decision gets made. So before you tell a single person you have retired, before the LinkedIn flip, before the announcement card, before the alumni note, before the email reply that says, "I'm out, talk to my successor," before the family group chat, before the neighbor in the driveway who asks, "So what's next?" There are 10 things that need to be in place, not as a precaution, as infrastructure, a standard reminder before going further. This is educational information about retirement law. It is not legal or financial advice. For your specific situation, work with a fiduciary advisor and a qualified attorney. I am retired. I'm not your attorney. What follows is research that should pass through a professional who knows your file before you act on it. The reason this matters is that the announcement itself is what attackers wait for. That sentence is doing a lot of work, so let me unpack it carefully. The Federal Trade Commission's 2024 Consumer Sentinel report logged 411,000 identity theft reports filed by Americans 60 and older in 2023. That is up 14% year over year. The 60-plus cohort carries the highest median per victim financial loss of any adult age group. Higher than the 30s, higher than the 40s, higher than the working age 50s. The losses concentrate in 2 categories: credit card fraud opened in the victim's name and government document fraud, primarily fraudulent tax returns and fraudulent benefit redirections. Both of those categories run on the same input: the Social Security number plus a confirmed identity signal plus an address. The breach cache files supply the first 2. The retirement announcement supplies the third. And the FTC's own scam targeting analysis is explicit about why the contact rate against any specific household spikes around publicly observable life stage events, retirement parties, obituaries, milestone birthday photos in alumni newsletters, professional network status changes, charity donation thresholds when a senior household is named in an annual donor report. The attackers do not need to be smart. They need to be patient and to subscribe to the right list. Most of them do both. The reason the mainstream advice missed this is structural. The retirement finance industry optimizes for managing assets. Reversing decisions and protecting against external attack are different optimizations, and they live in different professional silos. Your financial advisor is fighting a calendar more than they are fighting your tax bill. The calendar usually wins. The estate attorney handles documents but not credit infrastructure. The credit bureau handles freezes but does not coordinate with the SSA. The SSA handles benefits but not aggregator scraping. The result is that no single professional in the standard retirement planning workflow holds the complete checklist, and the checklist that gets handed to you was written for a world that does not have public records aggregators, breach cache files, or LinkedIn. Let me back up. I'm getting ahead of myself. The mechanism is what controls the rest of this video, so I want to walk through it slowly before I give you the list. The data brokers and the public records aggregators do not work the way most people imagine. They are not actively investigating you. They are passively absorbing every public signal you emit and matching it against the breach cache files they already hold, from the Equifax 2017 breach, the OPM 2015 breach, the Experian 2015 breach, the Anthem 2015 breach, the T-Mobile breaches in 2021 and 2023, and a long tail of smaller events. Those files contain Social Security numbers, dates of birth, mother's maiden name, old addresses, sometimes security question answers. They have been sitting in distributed storage cold storage on the legitimate broker side, hot storage on the criminal marketplace side, for between 2 and 10 years depending on the source. The aggregators only need a public signal that confirms identity. The announcement of retirement is exactly that signal. It is the missing handshake that turns a stale breach record into a live, sellable phishing target. The transition from cold to hot does not require any technical sophistication. It requires only a confirmed life stage flag. Imagine a filing cabinet in a back office that has one drawer nobody has ever opened. The drawer is full of records that became dangerous the moment somebody walked past and waved at the file clerk. The wave is the announcement. The drawer is your decade-old paperwork, the breach files, the joint accounts you opened in 2004, the beneficiary forms you signed in 1998, the Homestead exemption you filed when you bought the first house, the will from before HIPAA. The file clerk is the aggregator. Once the wave happens, the drawer opens, and the records are now in active circulation. That is the picture I want you to hold while I read the list. I read regulations for a living, retired or not. That is most of what I do. So when I tell you that the 10 steps below are the version most planning offices either skip or schedule for after the announcement instead of before, I am telling you what the regulations say, not what the standard intake checklist contains. There is a gap. The gap is the entire reason for this video. Step 1. Freeze your credit at all 3 nationwide consumer reporting agencies: Equifax, Experian, TransUnion. The statutory authority is the Fair Credit Reporting Act, as amended by S.2155 in 2018. The Economic Growth, Regulatory Relief, and Consumer Protection Act. Translation in plain language: the freeze is free, there is no fee, there is no time limit, and it does not affect your existing credit accounts. It blocks the opening of new credit lines under your Social Security number until you lift the freeze. You have to do it at each agency separately because there is no central registry. Each one has a website. Each one has a phone line. Half an hour total if the phones do not have a wait, an hour or so if they do. The freeze can be temporarily lifted in 15 minutes when you legitimately need to apply for credit, and reinstituted just as quickly. The objection most retirees raise is, but what if I want to apply for a card later? The answer is that the freeze is not a wall, and it is a door you control. Right now, the door is missing entirely. I'm about to be more confident than the case law warrants. Adjust accordingly. There is no published court decision that has tested whether failure to freeze credit constitutes contributory negligence in a fraud recovery suit by a senior victim. The lower court trend is moving towards saying yes, meaning that a victim who did not freeze may recover less from the bank than a victim who did. The appellate split has not happened yet, and reasonable attorneys are split on whether it will. So when I say freeze first, I am stating a strong preventive position that the doctrine has not finished catching up to. Do it anyway. The cost-benefit ratio is not close. Step 2. Freeze the credit of any minor child or grandchild whose Social Security number you have ever shared. School registration forms, pediatrician intake, old tax filings where you claimed a dependent, sports league liability waivers. Any of those is a leak point. The same statute permits a parent or guardian to freeze a minor's credit file, also free, also without a time limit. The freeze for a minor requires a paper application at each bureau. They will not allow online minor freezes for fraud prevention reasons of their own, but the form is short and the processing is reliable. The reason this matters at the moment of grandparent retirement is that synthetic identity fraud, where an attacker pairs a real Social Security number with a fake name and birth date, runs primarily against the credit files of minors because the file does not get checked for 10 or 15 years. By the time the child applies for a college loan and discovers a $40,000 debt in their name, the trail is cold. The retirement of the grandparent is a known trigger for these synthetic builds because the household is suddenly visible to aggregators who match the household to the dependents on the historical tax record. The dependents who were claimed in 1998, 2005, 2012, they live forever in the matched record side of the data broker industry. Step 3. Lock your Social Security online account before you announce anything. The procedure lives in the SSA's Program Operations Manual System under Section GN 02402.055. The function is called Block Electronic Access. It does what it says. Once the block is on, nobody, including somebody who has memorized your Social Security number, your address, and your date of birth, can log in to my Social Security and change your direct deposit, your address of record, or your benefit elections. The restoration is written only. You have to mail in a form, and depending on the field office, you may need it notarized. That slowness is the entire point. Speed favors the attacker. The block makes the attacker move on a paper timeline, and the paper timeline is one they cannot scale across thousands of targets. Said differently, this is the step that closes the most common middle-aged retiree fraud, the redirected first benefit check. The IRS audits roughly 1 in every 220 returns above 200,000. The retirement returns get audited at 3 times that rate, which is structural irony. But for the SSA's first benefit check, the redirection fraud rate documented in the Inspector General reports runs between 1 and 1.5% of newly claimed accounts.
That is between 1 in 70 and 1 in 100.
Higher than people assume.
Mostly preventable.
The block does not prevent legitimate applications. Those run through field offices on paper.
It only prevents the online vector,
which is the vector that scales. Step 4. Update the beneficiary forms on every retirement account you hold. Every 401k, every IRA, every Roth,
every old pension, every annuity,
every life insurance policy. The plan administrator's duty under ERISA Section 404 Sub 1D is to pay according to the beneficiary form on file, not according to your will, not according to your verbal wishes,
not according to fairness.
According to the form. If the form names your first wife, who you divorced in 1996, and you have remarried, the form still controls. The plan administrator pays the first wife, and the second wife gets to litigate. The Seventh Circuit alone has half a dozen of these cases on the published docket. The Supreme Court reaffirmed the principle in Kennedy versus Plan Administrator for DuPont in 2009. The form is the form. And here is the part that bothered me most when I was reviewing this material. Most plan administrators will not flag a stale beneficiary form during a regular review. They will accept the form you filed in 1998 and pay accordingly. The duty is on you. There is no automatic update. There is no, we noticed you got remarried. There is the form and there is the date on it, and that is the entire universe. Honestly, when I first started seeing these cases stack up in the early 2000s, my reaction was that surely the Secure Act would build in a remediation period, or that some plan administrators would notify participants of stale forms, or that the IRS would build a centralized reminder.
None of that has happened.
The form on file is the form on file. 26 years in, I have stopped expecting a fix. The honest answer is that the burden lives with the participant, and the participant is the only one who can make the form current. 20 minutes per account.
The phone number is on every quarterly statement.
Step 5. Review or rewrite your will.
Look at your revocable trust if you have one. Look at the date on the cover page.
If the date is before 2010, the document is almost certainly outdated in 3 specific ways. First, it was drafted before the Secure Act of 2019, which means any retirement account language inside it references a stretch IRA that no longer exists for non-spouse beneficiaries. The 10-year rule has replaced it. The math on bequests built around the stretch is now wrong, and the tax pass-through to the heirs is materially different. Second, the executor or trustee you named 10 years ago may have died, moved out of state, or, and this is more common than people admit, fallen out with the family. A successor trustee who cannot or will not serve is functionally identical to no trustee at all, and the probate court appointment that follows is slow and expensive. Third, the document probably does not reference digital assets, your email, your password manager, your iCloud photos, your domain registrations, your cryptocurrency wallets, if you have any, because the revised Uniform Fiduciary Access to Digital Assets Act was not enacted until 2015, and your state did not adopt its version until later. A document drafted before 2010 contains a hole that has only widened since. What this looks like at the kitchen table is a 30-minute appointment with the attorney who drafted the original, plus or minus a small fee for amendments, or a complete rewrite if more than 2 of the 3 holes apply, which is the more common situation than the planning industry advertises.
I want to flag something here.
Reviewing a will after retirement and reviewing a will before announcing retirement are 2 different procedural events. If the document is amended after the announcement and then contested by a relative who claims you were under undue influence during the post-retirement transition, that claim is harder to defeat than the same claim against an amendment dated 3 months before the retirement date. The cases are not consistent across jurisdictions, and smart attorneys disagree on how heavily to weight the timing. But the conservative reading, TT, and the one that aligns with what I saw across the contested amendment cases I worked on during my practice, is to amend before, not after. The dating of the document when contested years later becomes its own piece of evidence. The pre-retirement date is cleaner. The post-retirement date invites argument. Step 6. Retitle joint accounts with care. The cleanest version of this step is the most counterintuitive one. The standard advice, usually given over the phone by the bank's retention specialist, is to add an adult child as a joint owner with right of survivorship for convenience, to make sure the funds are accessible if you become incapacitated. That structure is a probate avoidance tool.
It is also an immediate ownership transfer to the child.
The child, the moment you sign, owns a present interest in the account. If the child is sued, divorced, files bankruptcy, or simply spends the money, the funds are exposed. The Internal Revenue Service treats large transfers from joint accounts, where the joint owner contributed nothing as gifts subject to gift tax reporting, which most families do not realize until the audit letter arrives. A pipe joint with a pinhole leak you only see in the bill. That is what convenience titling does. The slow leakage is invisible until the divorce decree, the IRS lien, or the estate accounting. The cleaner mechanism, for bank accounts, is the payable on death designation, POD. The funds remain yours during life. They transfer at death without probate. The child has 0 ownership interest until that moment. Same outcome on the survivorship question. None of the exposure during life. For brokerage accounts, the equivalent designation is transfer on death, TOD, governed by your state's adoption of the Uniform TOD Security Registration Act. 47 states have adopted some version, worth 1 phone call to the brokerage to set up. Free in every state I am aware of. The bank or the brokerage will sometimes resist because the joint titling is the more profitable structure for them in the long run, but they cannot refuse. A POD and TOD are statutory rights. Step 7. Update your HIPAA authorization and your healthcare power of attorney. 45 CFR Section 1, 64.508. The authorization must be specific, signed, dated, and in many states notarized. The reason this matters in the retirement window is that healthcare POA documents drafted before 2003, that is the year HIPAA's privacy rule went into effect, usually do not contain the right release language. So the document names your spouse or your daughter as the agent, and then the hospital tells the agent it cannot share medical information because the HIPAA release is missing or incompatible. The agent has the title and none of the access. I sat through enough hospital lobby conversations during my practice to be specific about this. The document is not optional, and the date of drafting is the diagnostic test. Pre-2003, almost certainly broken. 2003 to 2010, possibly broken depending on the state and the drafter.
Post-2010, usually compliant if the attorney was current. A second piece.
The HIPAA authorization should name a successor agent.
Most original documents name only the spouse.
If the spouse is also incapacitated, which happens more often in retirement than people plan for, particularly in two-spouse households where both are over 70, the document silently fails. The successor designation costs nothing to add. Most states require a notarized re-execution. A third piece, often missed. The authorization should explicitly extend to mental health records and substance abuse records, which under federal law require separate release language above the standard HIPAA authorization. Most older documents do not include either. If the medical event in retirement is a stroke that produces cognitive change or a hospitalization that triggers a behavioral health consult, the standard release will not cover the records the agent most needs to see. Step 8. Review the Homestead exemption on your primary residence. State-specific. Florida is the strictest. Form DR 501, deadline March 1st of the year, claimed. Texas has its own form, also annual.
Iowa similar.
The reason this lands in the retirement window is that retirement frequently coincides with relocation or downsizing, and homestead protection of the primary residence from creditors does not transfer automatically across state lines or across address changes within the same county. If the homestead claim is missing or stale, the equity in the house, which for many retirees it is the largest single asset, is exposed to a category of creditor claims that an active homestead designation would block. Not all categories. Federal tax liens still attach. Most contractor mechanic liens still attach. But the broader civil judgment category, the consumer debt category, the catastrophic medical bill category, those are the ones the homestead exemption was designed to wall off, and the protection only runs while the claim is current. In Florida, the protection is functionally unlimited in dollar value for an established homestead. In other states, the exemption caps vary from a few $1,000s to several $100,000. The number on your house in your state is worth knowing before you announce, not after a creditor has filed. Step 9. Opt out of the public record aggregators. There is no federal statute that requires opt-out compliance. The framework is voluntary, which means each aggregator publishes its own opt-out URL and processes requests on its own schedule.
White pages.
Spokeo.
Been verified. Intellius. My Life. Radaris.
Truth Finder.
People Finder. Instant Checkmate.
The list runs to about 30 active aggregators with non-trivial market share. The AARP maintains a current list of opt-out URLs for the major ones. The opt-out is free at everyone I have checked. The catch is that the aggregators rescrape from their underlying public record sources on a quarterly cycle, so the opt-out has to be repeated annually. About 45 minutes of clicking the first time, 20 minutes a year after that. Most retirees skip this entirely because they assume their privacy is intact. The aggregator data is what feeds the call pool lists priced and sold to scam operations targeting newly retired households. The price per 1,000 records on the criminal marketplace side runs higher for verified retirees than for working-age adults, which tells you everything about which population is being targeted. If your advisor told you you're not on social media, you're fine. They were repeating training from a decade ago. The regulations, or rather the lack of them, have moved. The exposure mechanism is passive aggregator scraping, not active social media posting. Different attack surface.
Different defense.
The advisor who reviews your plan next year was trained on guidelines written before this provision was revised. Step 10. Enroll in the IRS Identity Protection PIN program. Publication 5367. The procedure lives at irs.gov/IP PIN. You enroll. The IRS issues you a 6-digit PIN.
Annual renewal.
Once enrolled, the IRS will not accept any electronically filed return under your Social Security number unless the matching PIN is included. This closes the SSN-driven tax refund fraud attack vector specifically for retirees, because the first retirement year tax return is structurally different from the prior years. different income mix, often larger one-time distributions, possibly a state of residence change. And that structural difference is exactly what fraudsters look for to fabricate a fake return ahead of yours. The PIN forces them out. Annual renewal takes 10 minutes online. The IRS expanded the program to all taxpayers in 2022 after running a multi-year pilot, meaning anyone listening can enroll today regardless of whether you have ever been a victim. If you want the regulatory breakdowns I write up between videos, one rule per issue, more compact than the channel, more specific to a single procedural step. The Mercer memo arrives every Thursday morning.
Free.
The link is in the description below this video. Most weeks it is one rule, one case I worked on during my practice that the rule explains, and one specific action you can take that week. It is the written companion to the channel for viewers who want a checklist instead of a rewatch. Now, the order of those 10 steps matters. Most planning offices that touch any of these touch them in the wrong sequence. The credit freeze, the SSA lockout, and the IRS PIN are the three that need to be in place before the announcement because they close the highest volume passive attack vectors. The beneficiary forms, the will, and the healthcare POA need to be in place before the announcement because amendment after announcement creates the undue influence litigation exposure I mentioned earlier. The joint account retitling and the Homestead review can technically happen after the announcement, but the cleaner audit trail puts them before. The aggregator opt-out can happen anytime, but its value compounds the earlier you do it because the rescrape cycle means each delayed quarter is another quarter of exposure. That leaves the minor credit freeze, which most people never do at all, and which I would put in the before pile if there are dependents in the household. A river with a small branch upstream that diverts most of the flow. That is the right way to picture the whole sequence. Each of these 10 steps is a small upstream branch.
None of them individually feels like much.
The cumulative effect, once they are all in place, is that the announcement, when it comes, is broadcast into a system where most of the obvious attack surfaces are already closed and the documents the family needs are already current. The announcement, after that, is just the announcement. The infrastructure handles the rest. Speaking to the 70-year-old in the audience, and I know there are a lot of you, the reason this video is framed as before you tell anyone instead of after you tell everyone is that I have read enough post-fraud reconstructions to know that the average recovery timeline for a senior identity theft victim runs 18 to 36 months and costs between $1,200 and $4,000 in direct expenses, plus an unknown number of hours of personal time. The $1,200 floor is the FTC's median figure. The $4,000 ceiling is the upper end of what the cases I sat through during my practice averaged. And those numbers do not include the indirect costs, the credit score damage that affects insurance premiums, the time spent on hold with banks and bureaus, the documentary toll of repeating the same story to 20 different intake clerks across 20 different agencies. The full cost, if you try to honestly itemize it, runs much higher than $4,000. The 10 steps above, end-to-end, take roughly 4 hours of weekend time and cost $0 in fees if you do them yourself, plus whatever the attorney charges for the will or trust amendment. The ratio is uncomfortable. Most retirees still do the after-the-fact recovery instead of the before-the-fact prevention, because the before-the-fact prevention is what nobody hands them a script for. A specialty financial planner will not be your attorney. The retirement law side of this, where the will, the trust, the healthcare POA, needs an attorney with a current license in your state. The credit freeze side, the SSA lockout, the IRS PIN, the aggregator opt-out, and the beneficiary updates can all be done by you directly with the relevant institution. The cleaner planning offices coordinate both halves. The throughput-driven planning offices skip both halves and move directly to the asset management conversation, which is where their billing structure rewards them. It is not malice, it is the engagement scope. 12 minutes per claim does not allow for what you just heard. There is an open question about whether the order I just gave you is right for every household, and I want to be honest about it. If you have a dependent with special needs, the special needs trust review goes ahead of step 5, because the disability benefit eligibility rules under SSI are unforgiving on countable asset transfers, and a routine will amendment can disqualify a dependent who is currently receiving benefits. If you have a small business that is closing or transferring at retirement, the entity dissolution and the shareholder agreement supersedes Step 6 because joint titling on business accounts triggers entirely different doctrines. If you are the surviving spouse of a recent decedent, the survivor benefit election timing under the Social Security Administration's procedures may override the SSA lockout in Step 3 because the lockout slows down legitimate field office activity that you may need fast. If you hold a federal security clearance, even a retired status clearance, there are notification obligations to your former agency that come ahead of the public announcement, and they have their own timeline. Most households do not have those wrinkles. Some do. The wrinkles are the part that requires the attorney. The base list, the 10 steps as given, is the version that applies to the standard household and that almost nobody hears in the format I just laid out. One additional piece I want to add before we close, because I have been asked it on every related video and the answer requires more than a sentence. The question is, does this list change if the retirement is partial? If you are stepping down to part-time or to a consulting arrangement or to an emeritus role that keeps your name on the firm letterhead but removes the day-to-day, the short answer is no. The list does not change. The aggregators do not distinguish between fully retired and stepped back to advisory capacity. The breach cash match runs on the public signal of life stage transition, and the transition is the trigger regardless of whether you are still earning a paycheck. The credit infrastructure, the SSA lockout, the PIN, all of that needs to be in place at the moment of any public reduction in status, not at the moment of full exit. The will and trust review needs to happen at the moment your professional income drops materially, because the asset base reshapes around the income change and the document drafted around the old income may distribute around the wrong base. The HIPAA and POA work needs to happen at the moment your day-to-day routine changes, because the people who used to be near you in the office are no longer the same people who notice if something is wrong. The Homestead exemption needs to be reviewed if the partial retirement coincides with a relocation, partial or full. The aggregator opt-out needs to happen on the same cycle regardless. So the list applies to soft retirement, hard retirement, phased retirement, and any of the hybrid arrangements that have become more common in the last decade. 2 more pieces before we close. First, the order of announcement once the infrastructure is in place also matters more than people give it credit for. The cleanest sequence is immediate household first, then closest extended family, then professional contacts who need to know on a working timeline, then the broader friend and alumni network, then the public-facing channels last. Most retirees do this in roughly the reverse order because the public-facing channels, the LinkedIn, the office card, the alumni note, have institutional pressure attached. The boss wants to make the announcement at the all-hands. The HR system updates LinkedIn automatically when the offboarding is processed. The alumni newsletter has a quarterly deadline. By the time the household sits down to talk about it, the news has already broadcast. Get the infrastructure done before any of those institutional clocks start. Second, the announcement itself should not include the full list of what you used to do. The retirement community at large has gotten conditioned to retirement announcements that read like a resume. Title, years of service, awards, mentorship credits, charity board memberships. Each of those is an additional confirmation signal for the aggregators. Senior partner at a financial firm with 35 years of experience is a much more valuable target than retired professional. The shorter the announcement, the less linkable it is to the breach cache files. There is no need to be cryptic. There is also no need to be a complete profile. 2 sentences, dated, dignified. That is all it needs to be.
Name the date. Name the new state.
Skip the resume. The shorter version is also the more graceful version, which is the reason it tends to be the version your closest contacts actually remember. The longer announcements get archived and forgotten. The shorter ones get repeated. That is a small social benefit on top of the much larger security benefit, and the two are aligned for once. If this video earned its time, subscribing is the way to tell YouTube I should make more like it. The next video continues this directly. It walks through the documented case of a couple I represented in 2009 whose announcement of retirement preceded a series of attacks across exactly 3 of the 10 vectors above, and how the recovery sequence ran. Different format,
Same theme.
worth seeing what the attack actually looks like when it lands. So before you tell a single person, your assistant, the office, the alumni list, the retirement party caterer, the LinkedIn profile, the family group chat, those 10 steps need to be in place. Credit freeze at 3 bureaus.
Minor credit freeze for any dependent whose social security number is in the household trail. SSA online lockout.
Beneficiary forms updated on every retirement account. Will and trust review. Joint accounts retitled with POD or TOD instead of survivorship. HIPAA and healthcare POA refreshed. Homestead exemption verified or filed. Aggregator opt-out cycle initiated.
IRS IP PIN enrolled.
4 hours of weekend time. Done before the announcement, not after. The announcement, after that, is just the announcement.
Not a flare.
Not a triggering event. Just the news on your timeline with the doors already locked.
Rules govern. The instruction is the input.
Read carefully. File carefully.